Certainly welcome. I'm glad all of you could join us on this Saturday morning. This is the Originalism and Property Rights session, and our panelists today will examine the extent to which the Constitution protects property rights. The Fifth Amendment provides that private property shall not be taken for public use without just compensation. What is the original meaning of this clause, and has the Supreme Court stayed true to it? Justice O'Connor, in her dissent in Kelo v. City of New London, didn't think so, nor did Justice Thomas in his dissent in Murr v. Wisconsin. And today, we're going to find out what our panelists think about this issue. Let me briefly provide you with a quick overview of the format that we're going to follow today, which is pretty standard. I'm going to briefly introduce our four panelists. Each will speak for about 6 to 8 minutes, and then they'll have a brief opportunity to respond to each other or ask each other questions. And then I'll open it up to the audience after that. Certainly the bios are in the app and on the website, so I'm just going to hit some of the highlights to keep this brief. Our first speaker will be Professor Ilya Somin. He's a law professor at George Mason, and his research focuses on constitutional law and property law. And interestingly, in 2009, he testified on property rights issues before the Senate Judiciary Committee before Justice Sotomayor's confirmation hearings. He writes regularly for the Volokh Conspiracy blog, which I'm sure a lot of Federalist Society members are familiar with, and he previously served as co-editor of the Supreme Court Economic Review. Our second speaker will be Professor Thomas Merrill, who is a professor at Columbia Law School. He previously taught at Northwestern Law and Yale Law School. He also served as deputy solicitor at the Department of Justice, and I can't even begin to list all of his writings about property rights, but you will find that in his bio. Our third speaker will be Professor Richard Lazarus. He's a professor at Harvard Law School, where he teaches environmental law, natural resources law, Supreme Court advocacy, and torts. He has represented the United States, state and local governments, and environmental groups in the Supreme Court in more than 40 cases, and has presented oral arguments in 14 of those, most recently and most interestingly for this panel, in Murr v. Wisconsin. He's also filed briefs on behalf of governmental parties in many other regulatory takings cases. And he will be publishing, this is also interesting to me, and I know to my former boss, Susan Dudley, who was the administrator of OIRA, when this decision came down from the Supreme Court, he's publishing a book on the Supreme Court's 2007 decision in Massachusetts v. EPA. He previously worked for the Solicitor General's office, where he was assistant to the Solicitor General. And last but certainly not least, Professor Eric Clays, who is a professor of law at Antonin Scalia Law School. He's written widely in the fields of property law, private law, and constitutional law, and his current research interests focus on natural rights justifications for property. His main teaching interests include property, torts, jurisprudence, and intellectual property. And with that, I will now turn to Professor Somin.
Thank you. I'd like to thank Federalist Society for organizing this event and all of you for coming. In my talk, I'm going to talk about the original meaning of public use, how it constrains the government and what it can take private property for, and what it might mean for today if we move closer back to that original meaning. So the Fifth Amendment indicates that the government can only take private property if it's for public use, but for over 200 years now, there has been an active debate about what exactly that means. One side of the debate, what I call the narrow view of public use, says that a public use only exists if it's for a government-owned facility, such as a public road, for example, or if the property is taken for a new private owner, that private owner must have a legal duty to serve the entire public or give them access, such as with a public utility, for example. The other view, the broad view of public use, holds that virtually anything can be a public use so long as there's some potential benefit to the public. And this is the view that has been embraced by the Supreme Court in such modern decisions as Kelo versus City of New London and Berman versus Parker. In my book, The Grasping Hand, which I'm going to draw on today, I argue for the narrow views on originalist grounds, also actually on living constitution grounds as well, but that's perhaps for a different panel. And I think the evidence does support that position. So I'll talk first about the evidence as of 1791 when the Bill of Rights was first ratified. And at that time, we have only limited information about not only public use, but really almost anything having to do with the Takings Clause. It was not one of the parts of the Bill of Rights that was particularly much debated at the time. However, such evidence as we do have supports mostly the narrow view of public use. If you look at some of these sources that the founders were heavily influenced by, like Blackstone, John Locke, and others, they all drew distinctions between takings for public projects, publicly owned ones, and takings for private parties, and considered the latter illegitimate and beyond the power of government. If you also look at early decisions such as Calder versus Bull and Van Horn Lessee, both written by Supreme Court justices, they also suggest that takings from one person to another are unconstitutional and impermissible. And there's a number of early state court decisions interpreting state public use clauses, mostly in a narrow direction. Many originalists today argue that when it comes to applying the Bill of Rights to state and local governments, and those are governments that do the vast majority of condemnations, the right time period to look at is not 1791, but 1868. 1868, of course, is when the 14th Amendment was ratified and applied the Bill of Rights to the states. And for this period, we actually have a great deal of evidence. By that time, numerous state Supreme Courts had issued decisions interpreting the meaning of public use under their state constitutions, nearly all of which have wording very close to or identical to the federal constitution. And a large majority of those state Supreme Courts, approximately 2/3, actually ruled in favor of the narrow view of public use. The same position was adopted overwhelmingly by the leading legal treatises of this period, which dealt with the question of public use. And in the 1860s, people didn't have things like Westlaw and Lexis, so if you wanted to look up the meaning of legal terms, these treatises were far more important at that time than they are today. In addition, the narrow view of public use is much more consistent than the broad view, with the reason why the framers of the 14th Amendment and others at the time wanted to incorporate the Takings Clause against the states to begin with, which is that they wanted to protect the property rights of white unionists in the South and also recently freed African Americans. If the government can take property for virtually any reason it wants, as under the broad view of public use, then that provides very little meaningful protection for that purpose. Now, I will pause now to say that there are some people who go beyond the traditional narrow versus broad view of public use debate. There are a few modern scholars like Jed Rubenfeld from Yale and possibly Tom Merrill today. I'm not sure if he's actually going to make this argument, but just in case he is, I'm going to preempt it. And that is the argument that not only does the public use clause not constrain as much as the narrow view, but it doesn't constrain takings at all. It just sort of says if it's taken for a public use, then there must be compensation, but it doesn't say it must only be taken for a public use. I think this is linguistically possible, but it's just not in accordance with the original meaning. I already mentioned the evidence of the original meaning. I will just further add that in the entire 200-year history of this debate, I'm not aware of a single legal decision, either federal or state court, which actually has taken this sort of Jed Rubenfeld-like position. And while linguistically, I think this is a possible reading of the text. So is the view that there's an assumption there that takings must be for a public use, and that assumption is firmly embedded both in the original meaning and in the case law up to this point. So what if we were to go back to the original meaning of public use, as to my cards on the table I do advocate doing? I think this would lead to the reversal of the Kelo decision, the notorious 2005 case where the Supreme Court ruled that you can take property and give it to private parties just to promote economic development. I think it would also lead to what, to my mind, is the much worse decision in Berman versus Parker in 1954, which is the first decision where the Supreme Court endorsed the broad view of public use. That decision authorized blight and urban renewal condemnations and led to displacement of many hundreds of thousands of people, mostly poor and minorities, from their neighborhoods. So Berman versus Parker, I like to say, is the most important, terrible Supreme Court decision that even many law professors have never heard of, but they should hear of it, and we should talk about whether we really want to keep it or not. I think the answer is that it would be a good thing to get rid of, because abusive blight condemnations, while not as common today as in the 1950s and 60s, certainly still do happen on a considerable extent, and they still victimize the poor and disadvantaged, as is also true for economic development takings of the sort upheld in the Kelo case. Finally, I would mention that reversal of these precedents would have implications also for pipeline condemnations, which have become a big issue in recent years. In many states, it's possible to condemn property for pipelines, even though the pipeline is not a common carrier or a public utility of any kind. And these takings do sometimes harm large numbers of people, cause environmental damage, and the like. So I think, therefore, this is an area where the original meaning is significantly at variance with current doctrine, but I think it's possible to at least begin to bring current doctrine more in line with the original meaning, and overall the consequences of doing so I think would be quite beneficial, particularly for the poor and the politically weak, and those people who tend to get shafted when the government can take property for almost any reason that it wants. So on that note, I conclude, but I very much look forward to discussion. Thank you.
Thank you, Professor Merrill.
Okay, so I'm going to confine my comments to the original meaning of the Fifth Amendment's Takings Clause as of 1791 when it was adopted. Ilya alluded to this, but let me elaborate a little bit. We know very, very little about the original understanding of the Takings Clause as of 1791. As a condition of ratification of the main body of the Constitution, a number of states insisted that there be a Bill of Rights added to the Constitution, and as part of that discussion, over 80 states submitted over 80 proposed amendments to the first Congress for adoption as a Bill of Rights. Not a single state proposed adopting a takings clause as part of the original Bill of Rights. James Madison, who took it upon himself to be the sort of collator and main floor proponent of a Bill of Rights, basically added the takings clause on his own volition. We don't know why. It's always been a matter of considerable speculation. The original text that Madison proposed was similar to the text as adopted, except that it included the word necessary. And for some reason, the select committee that was placed in charge of scrubbing the Madisonian list of the Bill of Rights took that word out, otherwise modestly modified the takings clause and some of the other provisions of the Bill of Rights. But there's no indication as to why they did that or what their thinking was. The House had some public discussions about the Bill of Rights. Some provisions, like the religion clauses, were debated quite extensively. Not a single person raised any point about the takings clause. The Senate at that time, it was passed along with the other package of rights that was approved. The Senate at that time did not keep a journal, so we don't know what discussions took place in the Senate. The Senate also approved the Bill of Rights, including the takings clause. 12 amendments were then sent to the then 14 states. Vermont had slipped into the Union by the time this happened. And 8 of them approved the Bill of Rights, or at least 10 of the Bill of Rights. There's no public discussion in any of the ratifying procedures as to what they thought the takings clause meant. So the bottom line is that we really know very little about the takings clause. I think the main sources that one would look to, if we were strictly confining ourselves to original meaning, would be to look at the text of the clause and also to sort of well understood background propositions understood at the time of the adoption of the Takings Clause. So the first thing I'll address is the public use requirement that Ilya mentioned, discussed exclusively, really. Ilya gave you sort of the 19th century living constitution version of the public use requirement. I'm going to give you what I think is a more plausible original understanding of the public use requirement. I don't deny that today public use is understood to be a restraint or condition on the exercise of eminent domain. Every justice of the Supreme Court thinks that. They've even taken to speaking of the public use clause of the Constitution as a sort of subpart of the Takings Clause. But I think it's doubtful that if you look just at the text of the Constitution, which is the main source of our understanding as to what the framers understood by the meaning of the Takings Clause, that's not clear at all. In fact, it's quite doubtful. So the text says, "Nor shall private property be taken for public use without just compensation." You note that the critical prohibitory word "without" occurs before just compensation. There is no prohibitory word that occurs before public use. The words public use clearly modify the word taking or taken. So grammatically, for public use indicates that the Takings Clause is about a subset of takings of private property, not all of takings of private property. What else, if in fact the framers had meant for public use to be a limitation, they would have said something like private property shall not be taken except for public use nor without just compensation, but they did not write the clause that way. So what other types of takings of private property might occur besides takings for public use? Well, there's really quite a few, all of which, many of which were clearly well established by 1791. You could take property when somebody didn't pay their taxes. You could have forfeitures of property when someone committed a crime using the property. You could take property for unpaid debts. The government could take property by having government agents commit torts that destroyed your property, and so on and so forth. I think most plausibly what the plain meaning of the Constitution indicates is that the compensation requirement is restricted to a different type of taking, a taking for public use, as opposed to those other types of government takings of private property. So in effect, I think one could fairly say that the framers may have anticipated or assumed that the just compensation requirement would be applicable to something called takings for public use, but they did not, by the language of the Constitution, require that as a limitation on the power of eminent domain. Now, a very common objection at this point is, well, doesn't that mean that the Constitution would permit takings for private use without just compensation? And doesn't that contradict the sort of natural rights assumption that you can't take property from A and give it to B, Calder versus Bull, concurring opinion by Erdl, and so forth? A couple of possible responses to that. One, of course, three actually. One is that there may be some other clause of the Constitution that prohibits private takings, the due process clause perhaps, in its substantive guise. Another might be that there's some kind of unenumerated right. We heard a big panel this morning about unenumerated rights. Maybe there's some kind of unenumerated right to prohibit takings for private use. Another possibility, which intrigues me, is that the framers may have used the words taken for public use because they didn't have a word to refer to compulsory acquisitions of property in which property is taken to be used as property in some other, in the hands of some other person for some kind of affirmative purpose, as opposed to being taken for payment of taxes or forfeiture or something of that nature. The word eminent domain, which was coined by continental theorists, did not really enter into American discourse until the 1830s. So if the framers were looking for a word like that would be what we'd call today eminent domain, they may have not had that word ready at hand. They may have used taken for public use to be roughly synonymous to a compulsory taking or taking for eminent domain. If that's in fact what they had in mind to distinguish what they were talking about from forfeitures and taxes and things of that nature, then essentially the Takings Clause would say that any taking, public or private, requires just compensation. But in any event, maybe in the mid-19th century, everyone got all excited about this narrow interpretation of public use and so forth. I don't doubt that, but that's a living Constitution argument, not an original meaning argument. With respect to regulatory takings, however, I do think that the Constitution, as originally understood, can give rise to a regulatory takings doctrine. And I say this for the following reason. The framers were well aware that there was, in addition to this incipient power of takings for public use, there only 2 states had clauses like that before the Constitution was adopted. The Northwest Territories statute also did, but there was virtually no jurisprudence about this. But in addition to authorizing or saying that takings for public use require just compensation, the framers were surely aware that the right to regulate public nuisances was well established. It had been around since the 15th century. And it was well established that when you regulate something as a public nuisance, you're not required to make just compensation. So you had these 2 understandings, the new understanding that you had to pay just compensation for public use takings, and the well-established understanding that you didn't have to pay compensation for public nuisances, what then in the 19th century quickly became called the police power. So I don't think there was probably any discussion or even explicit deliberation about how these two understandings, one new, the other old and settled, would be accommodated with each other. But if they gave any thought to this at all, or I think logic would require, that you couldn't have one swallow up the other. You couldn't have the just compensation requirement be interpreted so broadly that every sort of taking of private property by state action would require compensation, and we have forfeitures and taxes and so forth. Nor, on the other hand, could you have the public nuisance idea, which becomes the police power, construed so broadly that the government could just label it a police power exercise and not have to pay just compensation. What you would logically want to have is some kind of boundary maintenance provision or some kind of anti-circumvention provision that would say that the government can't use the word public nuisance or police power in order to evade its responsibility to compensate when in fact it should be paying compensation. So you'd have to have some kind of substantive understanding of when the compensation requirement necessarily applies. And I think what you would do at a minimum would be to say that the power of eminent domain, the power of compulsory acquisition is used to acquire resources that ordinarily a non-governmental party would have to purchase in the open market. So if the government uses a regulation that in effect acquires a resource that a private party would have to acquire in the open market, the government either has to purchase it or use the power of eminent domain, and the government can't label it a police power measure or a public nuisance regulation and get away with the compensation requirement. That would give you, I think, a minimal regulatory takings doctrine straight from sort of well-established principles that come straight from 1791. And would justify some type of regulatory takings doctrine. Now, I don't think it would necessarily justify the one that we have, which is kind of this Baroque edifice. Richard will no doubt defend Murr and so forth. So I think it's very unlikely you could get to where we are today from originalist premises, but you could certainly get to some type of a regulatory takings doctrine that would be non-trivial. It would mean, for example, that if something like conservation easements are routinely gifted or acquired, as they are today, not necessarily in years past, but they are today, that the government couldn't compel a conservation easement by regulatory command. In other words, Penn Central would have to be reversed. Thank you.
Well, I understand my role in this panel. It's to be the progressive provocateur. I have no problem with that, and I'm going to happily embrace it. So in my 8 minutes, I'm going to make briefly 3 points. The first is the Supreme Court has thrice stumbled on the original meaning of the Just Compensation Clause. Second, the court's recent decision in Murr, Wisconsin happily limits the damage. But third, the court's even more recent decision in Nick v. Township of Scott compounds the court's earlier errors, ironically places at peril the very property rights it purports to safeguard. So turning to the first, what are the 3 times the court, I think, has abandoned the original meaning of the Just Compensation Clause? In Pennsylvania Coal in 1922, and twice in June of 1987, it was a bad month for the original understanding of the Just Compensation Clause. In early June, in the First English Evangelical Church v. City of Glendale, and second, at the end of June, I believe it was the last day of the term, in Nolan v. California Coastal Commission. In Penn Coal, Justice Oliver Wendell Holmes invented the regulatory takings doctrine in the absence of any pretext of adhering to the original meaning of that clause. Where did he get that idea? none other than one of the greatest lawyers of the 20th century, John W. Davis, who was representing Pennsylvania Coal. But it was a throwaway line in Davis's brief. He focused mostly on the due process clause, the contract clause. He had less than 2 pages in his brief on the just compensation takings argument. He made zero effort to claim any original meaning. He cited no Supreme Court cases, no state Supreme Court cases, and for a reason, there weren't any. Nor did Holmes himself in Penn Central. It was clear to everybody, and it's been clear to many people since, with a few dissents here and there, including no less than Robert Bork, that takings meant what it meant back then, which is a physical takings. That was the plain meaning of the term. I always admire Tom's arguments, but I'm not buying the idea of a dormant just compensation clause, which extends to non-physical takings. If there's a place for that, and I think there is, it's in the substantive due process clause, as he was saying, for the public use notion. The court's second stumble was in the first English ruling in early June of 1987, when the court held the just compensation clause mandated the just compensation remedy for violations of the Fifth Amendment. The text simply doesn't support that conclusion. The Fifth Amendment makes takings unlawful absent a just compensation. It does not prescribe the remedy for that violation, any more than announces a remedy for any of the other limits the Fifth Amendment poses on governmental authority. Therefore, the Fifth Amendment says no person shall be held answerable to infamous crimes unless presentment of grand jury indictment. No person shall be deprived of life, liberty, or due process, life, liberty, or property without due process, and nor shall private property be taken for public use without just compensation. So it says what the government can't do. It does not remotely purport to prescribe a constitutionally required remedy for past regulatory takings. It just establishes a condition precedent for the future. The remedy question for past temporal violations is entirely distinct, and it's not answered by the Constitution. The court's third misstep in the original meaning of just compensation clause was in Nolan in late June of 1987, when the court equated an unconstitutional condition with a regulatory taking, when it's clearly at most a violation of substantive due process. To posit, as Nolan does, that a permit condition is a taking, when an outright denial of the same permit would conceivably not be a taking, is nonsensical. When the justices first deliberated on the conference in Nolan, Justice Scalia acknowledged just that in his opening discussion. He said, this is not a regulatory taking. He said, this is a due process issue. But he had drunk the Kool-Aid and actually authored an opinion that put it in the regulatory takings category by the time the court reached a decision at the end of that term in June. But as Scalia later made clear in Lucas v. South Carolina Coastal Council, he was under no delusion this was all a matter of original understanding of the just compensation clause. The best he could then muster in Lucas was a matter of constitutional culture. My last 2 points are both the good news and the bad news. The good news is that in Murr v. Wisconsin, the court has mitigated the harm of its earlier mischief. By embracing a test of justice and fairness, it makes it harder for plaintiffs to prevail. The court does so by requiring courts in measuring the economic impact of a challenge regulation to account for the fact that many land use regulations, like those challenged in Murr itself, add enormous market value to land. Indeed, the reasons why the Murr property at the bend of the wonderful St. Croix River in Wisconsin was worth so much were the very land use restrictions they were challenged. That's why all 9 justices in that case, including the dissenters who disagreed about what the denominator test should be, acknowledged that the Murrs were actually not being treated at all unfairly. But now for the bad news, the Nick case from last June, where I think the court has made the regulatory takings problem worse. Here's my concern because of Nick. It will now be open season for Section 1983 regulatory takings claims against municipal governments. The just compensation awards mandated by Penn Cold and First English will now be joined by both attorney's fee awards and potentially punitive damage awards. The upshot is the likely perverse erosion of private property protection upon which landowner value depends. As a general matter, comprehensive land use restrictions enhance and don't diminish economic value. But a local government scrapped for resources, feel exposed to massive monetary liability under Section 1983, and faced with the vagaries of the regulatory taking test, they are likely to retreat from adopting needed laws, to landowners' ultimate detriment. It's not unlike what some believe may have happened with local police, worried about monetary liability for strict law enforcement, and they respond with less enforcement, to the ultimate detriment of the communities now facing higher crime rates. This time, however, I think landowners will be the losers.
Thank you, Professor Clays.
Thank you, Judge Branch. In my remarks, I'm going to make 2 points and try to illustrate the second with a case example. And so the first point is that in her opening remarks about the panel and the other 3 panelists, I think they've all focused much too much on the Fifth Amendment and not nearly enough on the 14th. As anyone in this room who's a litigator knows, and as Ilya alluded to, most of the action and practice with condemnation and regulatory takings is at the state level. And the Fifth Amendment applies to the federal government, seems so as of its text and its position after the Constitution of 1787. And if there are any doubt, Barron versus Baltimore established that, and nobody questions Barron. Now, the panelists can and have, I think, assumed quite reasonably that it's worth using the Fifth Amendment as a way to think about regulatory takings and other takings guarantees as against states. But when that assumption's made, it's on the ground that the 14th Amendment incorporates the Fifth Amendment and applies. And I want to just point out, and in my first point, just say, I'm skeptical that incorporation is the way in which property rights and guarantees in the federal Constitution are applied to the states. I'll assume that's one possibility, but it's just one of 3 or 4. And the 2 more viable ones go like this. One is that regardless of what the Due Process Clause in the Fifth Amendment meant, by 1867, 1868, enough antebellum courts had legitimated what we now call substantive due process, that the 14th Amendment Due Process Clause had a substantive component. So this is, I guess I'm politely disagreeing with Judge McConnell. I can't see because of the same Klieg likes as he complained about whether he's here now. But I think that the 14th Amendment, I am not sure about this, and I haven't committed myself in print to this, but from what I know, what I've seen, I think that the 14th Amendment Due Process Clause enforces substantive guarantees. And then separately, the 14th Amendment also has a privileges or immunities clause, and thanks to Corfield versus Coryell and the way abolitionists talked about Corfield versus Coryell, I think it likely that the 14th Amendment privileges or immunities clause made property one of the, we had a fundamental rights reading, and property was one of the privileges protected in a way that had substantive guarantees. And so to the extent we're talking about the original meaning of property, and the Constitution of the U.S. playing against states, those are the 3 theories we need to be thinking about: incorporation, substantive due process, and a fundamental rights reading of the privileges or immunities clause. So now to my second point. Whichever one, if one or more of those theories is a viable way to understand part of the 14th Amendment, then one needs to understand how property was understood as a penumbra of property and due process or a privilege, and how government justifications for restricting property rights are inhering in words like deprive or abridged. And I've done work on this, and so I'll just make a quick reference. What I'm about to say relies on a 2003 article called Takings, Regulation, and Natural Property Rights I wrote in Cornell Law Review, and a 2004 article called Public Use Limitations and Natural Rights from the Michigan State Law Review. And so throughout the 19th century, many state courts and a few federal courts worked out a principled set of distinctions saying, here's the kind of situation which the government has legitimate authority to condemn property via eminent domain, and here are the situations in which the government has legitimate authority to regulate using the police power. And anything that doesn't meet one of those 2, or the taxing power, is a confiscation and is wrong as a matter of natural law and is unconstitutional under due process, under state-based rights guarantees. And so there's 3 basic acceptable forms of government action that I'll focus on here. And the first is an exercise of eminent domain. And if the government needs to take property for a public use, it may do so as long as it pays just compensation and as long as it takes public use in the sense that Ilya was talking about in his remarks. Second, the government may regulate property, or second and third, there are two different ways the government may regulate property. One is the one that Tom was mentioning, that the power to regulate properties, the power to make one's rights regular, as Randy Martinet put it, by keeping one person's rights from interfering with someone else's rights, the power to control nuisances or control harms. The other form of regulation, though, is one that Justice somewhat anachronistically and after the fact, Justice Brandeis and Justice Holmes talked about laws that secure an average reciprocity of advantage. There are a lot of 19th century cases that recognize this idea. The most famous is an 1850 case out of Massachusetts called Commonwealth versus Alger by Chief Justice Lemuel Shaw. And in these laws, the government restrains how people use property in this one way to enlarge their use of the property in another way. And so in Alger, the state of Massachusetts, its legislature redrew the shoreline property boundaries to give people clearer property rights. And in substance, Shaw said that's fine because even though the rights change, they've changed in a way that provides clarity that's to the advantage of the owners. Anything that didn't meet these three tests was seen to be an unjustifiable confiscation of property. And I guess these approaches matter also just because if these approaches are part of the 14th Amendment, by the mid-19th century it was taken for granted that property would refer not merely to the right to exclude, kind of contrary to what Richard was saying. By the middle of the 19th century, courts are saying property is the trinity of the rights to control and to use and to dispose of property. And so the right to use and the right to dispose got protection under these doctrines on terms equal to the right to exclude. So the last point I want to make the illustration is just to illustrate a case a situation where this understanding makes an important difference. And the one I want to suggest is a case called Fallbrook Irrigation versus District versus Bradley. Fallbrook is a case from just before 1900, and in it, a person brought a substantive due process challenge to a law that forced her to let a county install an irrigation system across her property and then make her pay taxes to support the irrigation system. And in it, the Supreme Court said that the law is constitutional on two grounds. The court said that the law was a valid exercise of eminent domain, but in a separate part it said that the same law was also valid as what I was just calling a law securing an average reciprocity of advantage. I want to suggest that the first holding was wrong. That was a taking for, to the extent like an irrigation company ends up keeping an easement on someone's property, that's a taking for a private use for the reasons that Ilya was talking about. But the part about that law being being a regulation securing an average reciprocity of advantage, what the court called, I want to get the court's exact phrase, a regulation for the general advantage of those who are treated as owners of a common property. I think that's right. And that makes a very important difference because Fallbrook was a case that Tom, in a brief for the American Planning Association, argued in Kelo ought to justify saying that New London, if it takes property of Suzette Kelo and Kelo's neighbors in the Fort Trumbull neighborhood and creates economic benefits for New London, that's a taking for a public use. And the argument is that a taking for a public use means that the city wants to create economic benefits. Those economic benefits are a public use. What I would suggest that under the narrow reading of Fallbrook, there's not a taking for a public use. There's been a taking to transfer land to a commercial developer. But the thing you'd then have to ask in a Kelo kind of situation is, is the condemnation of property worked for a reciprocity of advantage, including the owner who loses property? And I want to suggest there's a big difference between a farmer having to give up a ditch easement and an irrigation easement to get back water and owners kicked off of their property in order to move somewhere else to make way for commercial development. So I think in Kelo situations, we have to ask two things. Has it been a taking for a public use in the narrow sense Ilya talked about? And then is there some reason why the system regulates property secure and average reciprocity of advantage? And a lot of the cases like Berman and Kelo, that reciprocity advantage test kind of focuses on what's different from the building and irrigation system on one side versus commercial development that moves out owners on another side.
Well, I want to thank all of the panelists for their opening remarks. And now that you've had a chance to digest what the others have said, do you have any responses to the other panelists? Do you have any questions of the other panelists?
Are we going in the same order?
Whatever order you would like.
Yeah. So I have a brief response to Tom, since he talked about many of the same issues I did, maybe a brief comment/question on Richard Lazarus's presentation. I think first, Tom can't get away with dismissing the 19th century evidence, saying, well, it's living constitutionalism, because even if those 19th century decisions had gotten the 1790s original meaning wrong, what they understood to be the case is relevant to the 1868 original meaning, when this stuff actually became applicable against state and local governments. And the idea that the Bill of Rights, when applied to state and local government, should be interpreted as understood in 1868 is actually rapidly becoming, if not the dominant position among originalists, and at least equally common with the position that we only look at 1791. Prominent originalists like Akil Amar, Kurt Lash, and others have endorsed this view. I think that Justice Thomas moves towards it a lot in the Chicago Second Amendment case, which incorporated the Second Amendment against state and local governments, and he relied there, in his opinion, a great deal on what the Second Amendment was understood to protect in the 1860s as opposed to the 1790s. The second is on this view, again, of, well, the public use doesn't constrain at all. If this really is the original meaning, I think it's a great mystery why nobody thought of this until the 1990s. There were lots of takings cases and public use cases from the early republic, yet no court embraced this argument. To my knowledge, I'm not even aware of anybody making it, though I grant there could have been cases where the records weren't preserved, or I haven't found them. But it's striking that this is such a novel invention. It's usually attributed to Jeb Rubenfeld in a 1993 article, but I managed to find another scholar who wrote a piece in 1991 who made a similar argument. So it's perhaps the original meaning as of 1991, at least according to some legal scholars, but it's not the original meaning of either the 1790s or the 1860s. Finally, on this point of, well, maybe public use denotes certain categories of takings, but not others, such as tax delinquencies and the like. I don't think public use can actually isolate those from eminent domain, because, of course, when the government seizes property to pay for tax purposes and the like, they still get to keep the property and use it. The same if they use up the property by destroying it when they commit a tort, and so on. So I think the phrase public use, either in its narrow or in its broad sense, would not actually serve to make that distinction. And then a small point on Professor Lazarus' presentation, and maybe I misunderstood his argument, but if the argument is that you shouldn't be able to have a cause of action for regulatory takings because the Fifth Amendment doesn't specifically specify a remedy, and therefore you can't file a case in court to get the remedy, it seemed to me that same reasoning would undermine every other constitutional right where the government, where the text of the Constitution doesn't specifically outline a remedy. If anything, the usual sense of regulatory takings violations is that this is one of the rare cases where the Constitution does more explicitly prescribe a remedy, namely compensation, right? So if that's not enough, then certainly, freedom of speech, unconstitutional discrimination, all the rest of it, where no specific remedy is prescribed, it seems like it's possible I'm misunderstanding the argument. I appreciate your clarification if I am, but if that is the argument, it seems to have implications that would require us to bite a lot of very painful bullets.
Okay, I'm next up. Yeah,
Yes.
Yes, the issue of incorporation and the 14th Amendment has come up in a number of panels, but from a number of comments. I was focusing simply on 1791, given my 8 minutes and so forth. I admit that there's an issue here. One thing I would point out is that the public use issue and the regulatory takings issue have been in kind of different silos with respect to whether the Supreme Court, the principal expositor of federal constitutional law, is reviewing federal judgments or state judgments. So the public use cases almost always come out of eminent domain proceedings. It's hard to find or think of a single regulatory takings case in which public use has been prominently debated. And so the cases that the Supreme Court has gotten until fairly recently that involve public use challenges have come out of the federal courts because it's the federal government seeking to condemn property. And the states have been left on their own to basically interpret their state constitutions in this regard. And it's only fairly recently with, I think, cases like Midkiff and so forth that you begin to see the Supreme Court treating the incorporation issue as allowing the same jurisprudence that develops under these federal eminent domain cases as well as state eminent domain cases as being the same with respect to public use. And of course, by then, if there's a de facto incorporation of public use as late as the Midkiff decision in the 1980s, then by then you've got the broad public use, public purpose interpretation is the dominant one, not the narrow one that both Ilya and Eric would like to see implemented. On Richard and Justice Holmes' lack of originalist support in the Penn-Cole case, actually, I think Holmes's argument in Penn-Cole is exactly the one I was trying to make. It's not a argument based on documentary evidence or on some kind of smoking gun about what the framers thought and so forth. It's an argument based on logic that, and Holmes made this fairly explicitly. I'll quote you the language. He says, "The protection of private property in the Fifth Amendment presupposes that it is wanted for public use, but provides that it shall not be taken as such without compensation. When this seemingly absolute protection is found to be qualified by the police power, the natural tendency of human nature is to extend the qualification more and more until at last private property disappears. But that cannot be accomplished in this way under the Constitution of the United States." So I think Holmes is basically making the same point I was trying to make, which is that if you have these two understandings, one that you have to compensate for public use takings and the other that you don't under the police power, you have to come up with some limiting principles. And the regulatory takings doctrine, which springs forth in that case most explicitly, is the limiting principle that he comes up with. Okay, one or two other points. Richard, on the Nix case, I think you're overreading Nix as sort of declaring open season for federal court adjudication of state regulatory takings issues. There's some lack of clarity about this, but the Supreme Court has never forthrightly said that state sovereign immunity is abrogated by the takings clause. There's a footnote in First English that kind of points in that direction, but it's not really been followed up. My view is that that state sovereign immunity still does exist, and particularly given the court's recent enthusiasm about state sovereign immunity. And therefore, if you have a taking by the state or an agency of the state, you ain't going to get any just compensation unless you go to a forum in which the state has waived sovereign immunity to allow you to get compensation. So I would think that what the Nick case does is it sort of strips away the sort of Williamson County argument that there's no constitutional violation until you've been denied compensation. It says that if the government takes your property and does not immediately promise to pay compensation, there's a constitutional violation. But the remedy is clearly compensation ultimately, and if the state hasn't waived sovereign immunity, the state's going to have a variety of defenses and so forth that will channel a lot of these cases back into state court, at least before final judgment is reached. And I have a bunch of other interesting notes here, but I can't read my own handwriting, so I'll pass it off to Richard.
All right, just three things quickly. First, on the original meaning of the regulatory takings clause, I want to embrace and paraphrase what Ilya said. And that was what he said about the public use requirement. If this was regulatory takings, the original meaning, then it's sort of surprising that the first time you ever see anyone make the argument isn't until the 1990s or the 2000s.
Can I just interject one more thing? John Lewis's treatise from the 1870s has exactly the argument about the language of the takings clause in public use.
Treatise actually in the 1880s.
Whatever, yeah, right.
So I think it's not happenstance you don't see the argument because it simply isn't there. To clarify, in answer to Ilya's question about what I was saying about remedy, I'm certainly not suggesting there's no constitutional remedy for these different violations, and the Constitution doesn't prescribe one. I'm simply saying the Constitution doesn't tell you what the remedy is. It doesn't say that it has to be just compensation, that it's self-executing. What it said, you have to figure out what the damages are, just like you do for any other constitutional violation. How has this person been damaged? What happened during the period of time that they could not use the property they wanted? It's a case-specific answer about how they've been damaged, just like for free speech, just like for everything else. It's just not answered by the Constitution, that they get just compensation based on sort of the ownership idea. On the sovereign immunity issue that Tom raises, I'm all for that. In other words, if it turns out that the court has not answered the sovereign immunity issue for the states, then I would favor that result. I'm not sure that's going to be the case. I will be ready there to brief it. But part of the implication of the court saying the Fifth Amendment is self-executing, that it demands a just compensation remedy. And this was briefed in the First English case. One of the main reasons that was given in the U.S. amicus brief in First English against this idea of a self-executing Fifth Amendment for just compensation remedy was they said that makes no sense, given it was quite clear that in the Constitution the court was not waiving the federal government's sovereign immunity. And the Fifth Amendment itself just applies on its own terms to the federal government. So the government argued this makes no sense because of that. It says it makes no sense in terms of the states as well for sovereign immunity, and the court rejected those arguments. I think you're right that the court has not yet squarely sort of addressed it since, but I think the clear implication of the ruling will be that and I think paradoxically and oddly, that the Fifth Amendment actually, now through the 14th for the states, actually overrides any waiver of sovereign immunity, which makes no sense to me, but I think they may have asked and answered that one, but I'd be happy to brief it.
The only reason you have to bring a federal takings claim in the Court of Federal Claims is because under the Tucker Act is because of the assumption of federal sovereign immunity.
And that was the argument they gave in First English why none of this made any sense, and the court ran right over it.
Yeah. I would just note that the 11th Circuit recently decided a decision saying sovereign immunity still does apply after Nick to takings cases, but there is a cert petition that if the Supreme Court grants it, this issue would be taken up. To my mind, it makes little sense to say that there should be sovereign immunity for the states here that doesn't apply to other provisions of the Bill of Rights. I'm not a big fan of the modern doctrine of sovereign immunity. Anyway, if you want living constitutionalism, I would say look there, where they essentially expanded the 11th Amendment to cover much more than this text, but that's perhaps a subject for another panel.
Professor Clays.
So I had 3 points to make, one in response to each of the other commentators. So with Richard's last point, I am not as impressed by the argument as that he made, or I'm not persuaded by the argument he made, I guess because of two.
Better than impressed.
Yeah, that's right, and that's why. Yeah, it's. I think that a lot of what he's pointing to can be explained by two facts, and one is it just took the legal system, the U.S.'s legal system, to a long time to decide after the Civil War and the adoption of the Civil War amendments that federal courts were going to get in the business of using the 14th Amendment to put limitations on states on a lot of topics. And so if it took a while for ideas about the federal Constitution limiting the way states dealt with property, that was happening on a lot of other topics as well. And in the 19th century, most of the action and most of the thinking about the right relation between the government and individuals and property was done in state courts. So if it took a long time, it's just everybody took for granted that the states were thinking these things through until such time as the federal courts started to get involved in enforcing the 14th Amendment. So I want to elaborate a little bit on one of the points I made, just to bring it, to say what I like and what I'm concerned about in Ilya's remarks and in his book, The Grasping Hand. I think the book is an excellent book in many respects. It does a great job on public use and what public use ought to mean. But if it is the case that the regulatory power, the police power, has as one of two subcomponents, this idea that governments may legitimately regulate property to secure and have reciprocity advantage, a lot of the situations that public use cases end up litigating are situations in which the government says there are a bunch of fragmented pieces of property and we ought to be able to coordinate them. And irrigation systems are one. In the 19th century, there were mill acts, and the same kinds of arguments are used now in the context of a commercial developer coming to a city and saying, nice neighborhood you got there would look better with a Walmart or a big office building there. And the question, the argument that comes back is, does the government have legitimate authority to make people surrender some property rights to create some higher value use? I think that theory of reciprocity of advantage I think it is historically in the toolkit for governments, and normatively it needs to be in a complete theory of government. And I'm concerned that the grasping hand doesn't talk about cases like Fallbrook or Head versus Amaskiag Manufacturing to the extent that one needs to give a thorough account of those cases. So the last point I want to make is that I want to give a different account of why the idea of the public use, no private use distinction might have been there in the constitutional understanding around 1788. So I'm going to read I guess the first thing is I want to take it for granted that lots of founders were saying to each other it would be awful or wrong or a gross violation of property rights for the government to take from A and give to B. Calder versus Bull came after the Bill of Rights was ratified, but I think it's safe to say that the sentiment expressed by Iredell and Calder versus Bull about no taking from A to B was shared 10 years earlier. But in Blackstone, in his commentaries, when he introduces property as one of the three fundamental rights in book one of his commentaries, Blackstone recognizes that the government may legitimately exercise eminent domain. But when he does, he rationalizes eminent domain saying the public is now considered as an individual, treating with an individual for an exchange. And if you think that is the public dealing as a corporation or an association with an individual, I think it's reasonable to infer the association is supposed to keep what it takes. If that's right, then when the Fifth Amendment says nor shall property be taken for public use, I think it's understood that the government doesn't have the power to take property for a private use. And we have to remember also that the Fifth Amendment is part of the Bill of Rights, and it could be that the Constitution already operationalizes both eminent domain and restrictions on it. There's no eminent domain clause in the Constitution of 1787, and this got litigated about 80 or 90 years later. But I think it's reasonable to infer that the federal government has what power of eminent domain it has through the necessary and proper clause, but the terms necessary and more so proper ought to structure how that power be exercised. And I think it's reasonable to infer that necessary and especially proper limit the kinds of ways in which the government can conduct eminent domain. And I would suspect if some founder had thought about this and put a writing about it in 1788, they would have said that a taking for private use seems improper. It's not proper in the course of taking property to carry into execution one of the enumerated powers.
Well, I thank you for that, for all the panelists, but I think we could go back and forth all day, but I'd like to open it up to the audience now, if you could line up, and we'll just go back and forth between the two microphones.
Yes, thank you. I'm Roger Pilon with the Cato Institute. My question is for Richard Lazarus. Your argument set aside the Supreme Court's regulatory takings jurisprudence, which, as Tom Merrill suggested, is a theoretical mess. Your argument that the government should pay only for a taking of the fee, not for various uses. Since we're talking about originalism here, let's look at the definition of property that the framers had. And there's no better example than Madison's famous essay on property in the National Gazette in 1792, when he said that just as a man is said to have a right in his property, so too he can be said to have a property in his rights. In other words, all the uses that go with property are property in themselves. And so when you deny compensation for taking those uses outside of a nuisance exception for some public use like a lovely view and the like, then you are taking something that reduces the value of his property. And so you're left with, and here's my question, how can you justify, given that, a case like Lucas, whereby the South Carolina Coastal Commission reduced the value of his property from about $1 million to virtually nothing, but because he was left with an empty orange peel with nothing inside of it, so to speak, he is entitled to no compensation. That strikes me as a paradigmatic case where regulatory takings requires compensation under the takings clause.
Yeah. All right. Call me old-fashioned, but Madison's essay is not in the Constitution. I look at the text of the Constitution.
It is instructive.
I look at the text. You can look at all the history and all the speeches given. I've certainly heard a lot of people talking about how you actually look at the text. And the text is about physical takings. That's what it's about. If there are other problems, then they have to be satisfied by other constitutional provisions. If there are deprivations of property without due process of law, then you should look over there. But don't look to the takings clause. As far as Lucas, you and I both know that in Lucas that was in terms of the factual findings upon which the court premised its decision. And I should acknowledge I was co-counsel for South Carolina in that case. The factual premise was one upon which was so ludicrous that Justice Souter said that he thought it should be dismissed as improperly granted. Kennedy wrote a separate concurring opinion in the case, basically saying he didn't really believe the factual premise of the case. It was a litigation bait and switch, which I could spend a lot of time on in terms of what the legal theory was. The legal theory that was posited in the lower courts in that case was that there was no nuisance exception to takings. That was their argument at trial. That was their argument, exclusive argument in the South Carolina Supreme Court. They were allowed to switch their argument in the Supreme Court, which most people aren't allowed to do. That's why the case has been litigated the way it was, and the lower court had assumed this idea that it was worth nothing. It was completely ludicrous that property was worth nothing.
You've defined property as it is nowhere else defined in the law of property.
Thank you.
All right, next question.
I guess this, I guess this question is directed to Professor Lazarus as well, although, can people hear me? Okay.
Yeah.
Although anyone else can answer. Regarding your comment about overruling Williamson creating an open season on municipalities, what really do things change in terms of being able to file a 1983 claim or seek 1988 fees? Even before Nick.
Yeah, 1983 allows for attorney's fee awards.
Sure,
that's going to be a huge. I mean, talk to any lawyers. Talk to any lawyers who do private property. That is a sea change in the incentive. You can have attorney's fees awards in takings cases. It's going to catalyze things.
But even before Nick, you're allowed to file a 1983 claim in state court. In fact, you're normally required to before Nick. You're able to seek the 1988 fees there too. Overruling Williamson practically only removes the removal trap requirement where you are follow your claim in state court, remove to federal court, and then have a 12B1 motion filed against you. Am I wrong here? Or?
I think you are wrong, but I think that they had to follow state procedures first to try to get just compensation under state law in a state before they could bring a 1983 case anywhere. That's why there weren't 1983 cases.
Oh, do you have something you'd like to say?
Yeah, so to the extent that this is open season here, it's open season in much the same way as the Bill of Rights and other constitutional rights create open season on state and local governments which violate them. And on the attorney's fees thing, of course, you can only get the attorney's fees if you win. So what Nick does is its biggest impact will be on that category of cases where state and local governments would have prevailed in state court or would have at least been able to drag out the proceedings a great deal in state court, perhaps, but then would lose in federal court if it was brought there. And if there really is a big divergence, if there really is a lot of cases like that, we actually don't know how many there are, but if there really is a lot of cases like that, that strongly suggests under protection of this constitutional right by the relevant state courts. And you have the same rationale for being able to bring these cases in federal court as we have for pretty much every other constitutional rights claims. That's why Section 1983 exists in the first place, to eliminate potentially or to create a venue that allows you to get around potentially problematic state courts.
And obviously my point was the chilling effect that an uncertain constitutional test has in regulatory takings on financially strapped local governments. That it's not that the cases will necessarily, it's the combined threat of now enhanced monetary liability, which will cause needed land use regulations not to be adopted, and that will actually be to the detriment of landowners.
And then the thing you have to think about is the chilling effect of putting a creche out on a public street, or chilling effect of a law that restricts the right to bear arms. And so you can, the thing that I would say about the concern about like the chilling effect is slot it through with 5, not just one right in the Bill of Rights, but all of them, some you like and you don't like, and ask whether you want the states to and localities to have chill effects to not to violate some rights.
Right, and they're not damage remedies for those.
Yeah, I would add, if these regulations really are creating enormous value, which increase the value of property, they should also be massively increasing the tax base, almost certainly enough to outweigh any attorney's fees that you're likely to get in a takings case, or even compensation for particular owners. So if it's just a revenue calculation, either these regulations are not actually creating all this great value, in which case the chilling effect is not a big deal, or they are creating a great value, in which case there's not likely to be much of a chilling effect.
Next question.
Hi, Gary Lawson, Boston University School of Law. I have one question for Richard and then one for any of the regressives who want to take it. For Richard, if Nolan versus California Coastal Commission had been written expressly in the language of unconstitutional conditions, would you have a problem with it?
Oh, I thought that was the right way to write it. I should acknowledge here, I wrote the government's amicus brief in Nolan v. California Coastal Commission for the Solicitor General. We are the ones who actually proposed that it was a regulatory takings framework. That was because I was representing my client at the time during the Reagan administration. None of us thought it actually made any theoretical sense to do it. But you have a client in a case. Yes, I think that would have been a much more defensible approach. I thought it was incoherent to approach it from a regulatory takings, completely coherent to approach it from a due process approach. I thought it was the better framework.
All right, and then for anyone else, this really comes out of Eric's final comments. Suppose it was December 14th, 1791. There is no Bill of Rights. There is no takings clause. What could the national government do on that day that it suddenly couldn't do the next day? The upshot being, is the language of the takings clause actually doing any relevant work in any of the questions that we're talking about?
Well, I think
Or
Will
is everything
Bowd's
handled
interesting.
by background norms?
Will Bowd's interesting article a few years ago, I think, fairly clearly establishes that in 1791, no one thought the federal government had the power of eminent domain.
Right.
So there wouldn't have been any sort of formal takings by the federal government. Now, it did have...
Well, in federal territories, maybe.
Yeah.
They had federal territories, and they had the impressment power. The only contemporary evidence about the takings clause comes from St. George Tucker's version of Blackstone, which was probably written a few years after the adoption of the Bill of Rights. And he thought that the takings clause was put in there because people were upset about the impressments that the Revolutionary War Army had executed during the war. They took horses and feed and things like that without paying for it. They didn't have any money to pay for it. And the clause was in response to those sorts of abuses. So to the extent there was still a federal army or navy, they would have episodes like that. The Constitution authorizes post offices and post roads, I believe. They mention roads. So there might have been situations where the federal government might have done something that would have been sort of like taking property if they didn't pay compensation. So it might have made a difference in those cases. Yeah.
So I too would commend Will Bowd's excellent 2013 Yale Law Journal article on this, which establishes, at the very least, I think that people did not think there was a general federal power of eminent domain at that time, but there were large federal territories, and also they knew that they were going to set up the District of Columbia. It wasn't yet set up, but they knew they were going to set up a special capital district. And there, the federal government would have all the same powers as a state government normally would have. So there, that would surely include the power of eminent domain. In addition, as Tom alluded, while I think Will's article effectively establishes that there was this understanding there wouldn't be a general federal eminent domain power, it might be possible to, and I don't know what the answer to this really is, but it might be possible that people would have thought there might be an eminent domain power for specific particular purposes like post roads, military impressment, other purposes. And potentially, if there was such a thing, they could even have thought, well, transferring property to private parties through eminent domain would even help promote some kind of raising of armies, like transferring it to a private cannon manufacturer or somebody that would then manufacture weapons for the army and so forth. So depending on whether you think that Will's argument shows they thought the federal government couldn't use eminent domain at all, or whether you think it's just that they couldn't use eminent domain except for a few narrowly specified purposes in aid of other enumerated powers, there could have been an impact there as well.
So just to expand a little bit on the last remark I made before we went to questions, if one is being an originalist to the point that one's trying to get to understand the plain meaning of the Constitution of 1788, I think the inquiry one needs to conduct is to ask, knowing what was known in 1788, is the power to exercise eminent domain, is that the kind of power that seems like a really big principle, important power? It's so big that if it were going to be in the Constitution, it would have to be enumerated earlier in Article 1, Section 8, or is it one that seems, though significant, not so principal or primary that it can fall in the ambit of the necessary and proper clause? And then the next thing one has to ask is, knowing what was known by lawyers 1788, if one were to think that eminent domain existed, would there be certain implicit limitations in how it be used, that compensation must be paid, that it must be used only for taking for private use? Was that in the intellectual background of eminent domain as understood in 1788, such that you're reasonably confident that ideas about necessity and more so propriety then limit the way in which a condemnation happened? And on that, Bode's article is excellent. I don't think it's the final word. More could be said.
Next question.
Professor Lazarus, I'd like to dive in and I would like to get a clarification on kind of I think what I understood to be your warning that we all better be careful because we're going to scare local governments away from regulating in ways that are going to we're going to lose value. And I want to just ask you about the value that we're losing. I think maybe you were referring to the idea that what the local governments are doing with zoning is addressing commons or coordination problems, but I mean, certainly you'd agree that what sometimes they're doing is restricting the supply of housing and property uses in a way that, does make those things more expensive and more valuable for the people that currently own them, but overall result in a sea of single-level ranch houses, as opposed to something where you have less restrictive zoning. So, I mean, what's the value that we're losing by saying that people can use their liberty to build houses as big as they want or build apartment buildings, even if that might make the cost of housing lower?
I'll give you an example. I would never suggest that local government of any kind, including land use planners, are immune from overreaching and being excessive in their regulations. I would never suggest that there can never be abuses by land use planners, just like there can be abuses by other parts of the government. My point here is, and I'm referring to the Murr case in particular about added value, about quite often in many circumstances, land value is increased by the fact you have certain kinds of restrictions, particularly in environmental sensitive properties. The Murr property is a wonderful example of that. The Murr property, if you ever looked at it, it was narrower than this property. Then this room here, between here and here, is about 50 feet wide and about 600 feet up, and about 3/4 of it was an transversable steep slope. You couldn't possibly walk. They had a little footprint down below. They had a bigger footprint up above. They wanted to build down below where the water came up to about almost the steep slope itself. As a result, all of the properties along the St. Croix River, including the Murrs who were at the bend, were subject to very serious restrictions to protect the coastal zone and protect the steep slope from destruction. And because of those protections, this property was enormously valuable. The property was worth about $500,000 and it was like a quarter acre, like it was almost nothing along. And it was because of the fact that everyone was restricted in exactly how they could build so it wouldn't destroy the natural resource. What they effectively wanted was they wanted to build the way other people couldn't build. So they would have gotten all the value of the restriction being placed on everybody else, which had protected this area and made it such an unbelievably gorgeous area. They wanted the restrictions to apply not to them, but to everybody else. And it was actually those restrictions which had prevented destructive development in that very sensitive area since the 1960s, which is why their property was worth so much. Absent those restrictions, it would not have been worth nearly as much. So the restrictions were, in fact, one which is a true reciprocity of advantage that Eric was talking about before. It was a real reciprocity of advantage case, and that's quite often the case when you got protections in environmentally sensitive areas. And that was the record evidence in the case, and that's why none less than the 4 dissenters in the case who believed in a different denominator test said they actually didn't think that on remand anyone would find a takings in this case. And that was because of the value created by the land use restrictions. And I was very pleased to see a Supreme Court decision which actually talked about it. I missed the opportunity to oral argument because I ran out of time to say that I thought it was a regulatory giving rather than a regulatory taking, but I'll use the moment here to say that.
Go ahead, Ilya.
So if the argument is that in that case or in some other cases, the regulation in question actually increases the value of the property more than it diminishes it.
I didn't say that. I said it increased a lot.
It increased what?
It doesn't always increase. It means you have to do a fair measure of the justice and fairness test. You actually have to look at how it adds value and not just at how it actually was a very small diminution in that case.
Okay. So my point is this, that those kind of questions are ones that should be analyzed at the stage of compensation. And it may be that if on net this regulation increases your value and doesn't diminish it, or increases it more than it diminishes it, then maybe the right compensation amount is zero. That's a distinct possibility. But I think that doesn't go to the question of whether there was a taking, because the question of whether there was a taking is a question of whether they've deprived you of any of the relevant property rights or of a sufficient amount of them or whatnot. That's distinct from the question of how much compensation you're owed. And under the current fair market value test, actually, if it really is the case that it increased the value of your property more than it diminished it, then you would get that result. But I think that that's the kind of thing that should be considered at compensation rather than at the stage where you analyze whether there's been a taking or not.
I'd like to jump in. My name was invoked. So I want to just, Richard's, this discussion about environmental restriction, I just want to walk through how the 19th century higher law rights-based police powers cases would treat the restraint on the use of property. And so the first thing you would ask is the person being restrained from using property to stop some sort of harm? And if somebody's using property in a way that has runoff that goes into a lake, like in the Tahoe Sierra case where the building causes erosion into a lake and messes up the character of the lake, you'd have to run through then whether there is something that would look traditionally like a public nuisance and could justify public action. But if there's a restraint for environmental benefits where there's not some public commons getting polluted, I think that you can say that there might be public benefits from creating public beauty, but the person's not invading anyone else's rights, so it's not a regulation for harm. So then you'd have to ask, and this is the part where Richard came over and kind of touched my shoulder, so the Eric's reciprocity advantage test. So you then have to ask whether the regulation is, whether an environmental restriction that restrains use is giving everybody reciprocal advantages. as you're conducting that analysis, the thing you have to think through is that people can get gratification from using property for a wide range of reasons. And some people might like to have property undeveloped and get gratification from that, but other people might want to use their property actively. And if you think that a restriction is going to interfere with a significant number of people's present plans how to derive benefit from the land, you have to worry that there's not a reciprocity of advantage because it's favoring the people who prefer the passive uses. And so then what you're left with is to say is the government, if it tells somebody you can't use the property to preserve scenery or something like that, that's a taking of a property right, a use right, a servitude, and the government can do so because the public then uses the absence of the building and other things for the public use of enjoying the scenery. The scenery is a public use, but eminent domain has to be used and compensation needs to be paid.
Thank you. Next question.
Thank you. I'm Judge John Curry from Chicago, and now we've had about 15 years since the Kelo decision. And if we look at, say, the scenario for liberal interest groups around the country on other constitutional issues, they've said, oh, geez, now we have Justice Brett Kavanaugh. Let's not go to the federal courts. Let's do activism in the state courts. And I had thought after Kelo, there'd be a plethora of state court decisions which would embrace the concepts of Kelo, the broadest sense of taking for public use conceivable. But I've not perceived that to be the case. In my own jurisdiction, approximately about 5 years before the Kelo case, there was a major public takings case in the state of Illinois, which was rather more conservative than the Kelo decision. And that case still remains good law in Illinois. And I'm not aware of any state Supreme Court decision that has thrown out what would be, I think, the Collinsville case and then has embraced the Kelo decision. So this is really an informational question. What has been the development in the state courts regarding the takings for public use pronouncements under Kelo across the country?
Chapter 7 of my book addresses this very question and goes through all of the decisions that we stumbled through 2016. And I think what you said...
Summarize.
Sure, I'm about to do that.
University of Chicago Press, 2015.
Yeah, and there's also a revised edition in 2016 as well. But the basic story is this.
Give me some 8 great books in reading, but thank you. Go ahead.
It's suitable for assignment at both the high school and the university level. But let me, in all seriousness, briefly summarize. There have been several state Supreme Court decisions since Kelo, which actually explicitly repudiate Kelo as a guide to the interpretation of their state constitutions. The Ohio Supreme Court has done this, the Oklahoma Supreme Court, and several others. And they embrace Justice O'Connor's dissent in Kelo, which says that economic development takings at least should be constitutionally forbidden, or they take a position that moves strongly in that direction. It is not quite true, however, that there have not been any state Supreme Court decisions going the other way. The New York Court of Appeals, in 2 decisions around 2009 and 10, they actually embraced an extremely broad definition of public use. In some ways, I think actually they embrace some things that the Kelo majority probably forbids, such as takings that might be very well be considered pretextual. The Kelo majority does still say that pretextual takings are forbidden, where the official rationale is a smokescreen for some scheme to benefit a private party. Though I admit, and I discuss in the book in greater detail, there's a lot of disagreement in the lower courts about what exactly is a pretextual taking and how do we tell if it's pretextual. But what's striking about these 2 New York decisions is that in those 2 cases, you had all of the indications of pretext, which in other jurisdictions have been said, might be unconstitutional. They were all there, and yet the New York Court of Appeals still said that this is perfectly fine. So more could be said, but that's the basic outline of the story. Most state Supreme Courts to address since Kelo have not actually embraced it, which is significant. It's a sign that sort of the tide of opinion on what is a public use is moving towards the narrow view, even if it's not necessarily moving all the way there. That's very different than the reaction to Berman versus Parker in 1954, where after Berman, into 15 years after that, numerous state Supreme Courts embraced Berman's holding with respect to condemnations for blight and urban renewal. So it's a different intellectual climate, I think, in these last 15 years than it was, say, 50 years ago. And even more importantly, before Kelo, people like me who favored a narrow definition of public use thought, well, you guys are sort of just weird, wacky extremists. We might still be wrong. We might still be extreme in a certain sense, but increasingly this position is embraced by at least a good many state Supreme Courts, even if certainly by no means all.
Yeah, I mean, I think between Kelo and the backlash to Kelo, the backlash was the true constitutional moment. And Ilya doesn't mention it, but there were like 44 states?
45.
45 now, excuse me, have adopted either constitutional amendments or state statutory limitations on eminent domain. And even the New York courts, bless their hearts, were strongly divided in the two cases that Ilya referred to. There were strong dissents in those cases to using eminent domain.
Only one dissent in one of the cases. One was 7-0, one was 6-1.
I have a couple of thoughts. One is, I think states, and here I'm relying on some of Tom's studies of public use cases in state courts. Courts had consistently for 20 or more years before Kelo, state courts had looked to see if a particular project looked really bad in some sense and used public use guarantees to knock out some of those. And so they were already in that habit and didn't change it. And I think a lot of the rest of the story is not really legal, it's political and cultural. If a right is important enough that voters are going to really care about it and single out somebody who's an elected official, depending on how they go on it, like gun rights are at that level, religious freedom rights are at that level, and the fight about Kelo put the condemnation to make way for a Walmart or for a Barclays Center at the same level, judges who are elected in states noticed.
Yeah.
And I would just like to comment by thanking the judge for asking a question about Kelo that left me out of the bullseye of that one.
We probably have time for one more question, so we'll take yours.
Hi, Holden Tanner, Yale Law School. Thank you guys for coming today. My question is for any of the panelists, and in general, it's this. What do you think is the appropriate level of deference for courts to give to state legislatures when they declare what a harm is within the scope of the police power? And specifically, I'm thinking about maybe an example like Hawaii Housing Authority versus Midkiff, and whether or not a state could, in theory, just declare that something like land oligopoly is a harm or a public nuisance, go through the formality of declaring it as a matter of positive law, and then take it without having to give just compensation.
So I'll start. I think the appropriate level of deference is very little deference, just like for other important rights under the Bill of Rights. I would add also that in the specific case of the supposed oligopoly in Hawaii Housing Authority versus Midkiff, there was no real evidence that there was an oligopoly. They said it was 72 private landowners. They said it had the so-called market power. Is actually very difficult to run an effective cartel with as many as 72 members, and that may be why the state, as far as I know, didn't even really consider bringing a traditional antitrust action against them because there was no real evidence of oligopoly. I would finally add that under the modern conception of police power, that power is so broad that if you say that anything that's within the state police power qualifies as a harm that can then be regulated without compensation or without being considered a taking, then they could do that with almost everything. Maybe if you go back to a narrow view of the police power of the kind that some people advocated in the late 19th century, things would be different. But under the modern conception of what counts as the police power, letting them declare that something is a harm and then giving it deference would essentially gut this particular provision of the Constitution. We don't allow that with respect to other constitutional rights. I don't think it should be allowed here either.
Yeah, this is a big problem, and that's one reason why I think that the better approach in trying to draw the line between the compensation requirement and the police power is to focus on whether the government regulation is effectively acquiring a property right which is ordinarily bought in the marketplace. So that gets you around the problem of having to define what the police power is and how broad the police power is. Justice Scalia and Lucas tried to put a limit on the police power by saying it would had to be something that was subject to regulation under the common law of nuisance, which sort of freezes the police power concept at a very kind of old-fashioned level. I don't think most people would agree with that. It's sort of too static a kind of conception of the police power, and we have lots of things that states do by way of regulation that go beyond that. So I think my preference would be to sort of try to make sure that, the power of eminent domain is being used when the government's actually acquiring property which is bought and sold.
And we're running up against a hard stop because just as a reminder, we have I'm going to ask, as soon as we conclude this, I'm going to have everybody go up to the grand ballroom for the Rosencrantz debate and luncheon. But I first and foremost want to thank all of our panelists